Thank you, Mr. Chief Justice, and may it please the Court. In common usage, to say that a person knowingly has possession of something is simply to say that that person knows what it is they are possessing. Same principle follows under the marijuana trafficking statute in 1613-31C, which says, and which imposes, by the way, a 5-year mandatory minimum prison sentence for any person who knowingly has possession of a quantity of marijuana exceeding 10 pounds. In plain language, in common usage, that means the person knows not just that he has marijuana, but also that he has marijuana that exceeds 10 pounds. The plain language of this statute really and truly decides this case. We don't get to any of the, tiebreaker canons of construction because they're not needed. The plain language suggests you have to know that you have more than 10 pounds to be guilty.
Aren't there Court of Appeals cases dealing with cocaine that hold differently with the same type of statute?
Yes, sir. There's a couple of things that make those decisions not quite relevant here for this court. Number one, they're construing the cocaine trafficking statute, which is
exact same words.
I'm sorry?
Exact same words.
No, sir. I disagree. The language in subsection A for the cocaine trafficking statute is any person who is knowingly in possession of 28 grams or more of cocaine. So actually the weight comes first with the cocaine statute. My position is, frankly, the cocaine statute is actually maybe a stronger case because the weight does come before the cocaine, Justice Namias. But the Cleveland case, which is really the genesis of this whole misunderstanding, which is a 1995 case from the Court of Appeals, without a scrap of actual statutory construction, simply just issues as though it's an edict. Look, the statute's not reasonably subject to the construction urged by the appellant. They don't take on the plain language of the statute. They don't even endeavor to do so in the Cleveland case, which was recognized by Judge Blackwell just last year in the Harrison case, the Court of Appeals case involving the trafficking statute, where he said, look, the appellant in this case is probably correct. The Cleveland case is likely wrongly decided. The statute, if you read it, seems to be plain language. Yes, you have to know that you have the requisite amount of the substance. And Judge Blackwell, in a nicely reasoned opinion, takes on the language of the statute and says, yes, you're probably right. So we have the Cleveland decision, we have the Barr decision, which followed it many years later without analysis again, just simply said, see Cleveland. And that's really where we stand. But this court, and no Court of Appeals case before this case, and this court specifically, has never passed on the marijuana trafficking statute in subsection C.
What about stare decisis?
Stare decisis, I'm glad you brought that up, Justice Namias. I'll point this court, let me answer your question by simply saying we don't have stare decisis from this court, number one. Two,
Until overruled by this court, though, that's the law. The Court of Appeals case is the law of the state.
Correct, sir. And we don't contend it's not. But we don't have stare decisis from this court as to, specifically, or any court, as to the marijuana trafficking statute, as to subsection C. There is none. There simply is none. There's only a construction of subsection A, the cocaine trafficking, from Cleveland. And as this court just said recently, and this is, I think, also in response to the appellee's argument of legislative acquiescence as a method of statutory construction, which we would disagree with, but this court in Jackson, 2010, overruling the Crane decision, of course, Jackson at 287 Georgia 646, there The word cause in the felony murder statute was at issue, and the Crane decision from 1981, we're talking almost 20 years of precedent and direct precedent on point from this court, where this court went back and said, look, we missed it on cause. Cause was right the way we're going to do it now.
One difference, in Crane, it would be hard to point to anyone who had a reliance interest on the statute as construed. Here, though, you've got literally thousands of drug cases that have been investigated and prosecuted that if we change the Court of Appeals rule, would have a real change in how the state investigated and prosecuted cases, and in a way that often couldn't be replicated. You couldn't go back and fix it. So what about the reliance interests in this kind of case?
Well, Justice Namias, I would respond by saying this. I don't think, and I don't believe, and if you look at the cases, I think it's supported, that the factual scenario where it's truly, truly an issue, whether the individual possessor of a threshold amount of 10 pounds of marijuana has no real indication that what he has is significantly more than what he thinks he has. In other words, where the person knows he's got marijuana of some amount, or at least he should know from a willful blindness sort of state, which knowingly would, of course, willful blindness would meet that. We just don't have very many cases where the facts, like Mr. Wilson's, really lend themselves to this sort of situation. So I would say significantly decreased reliance interests in response to your question. Here, Mr. Wilson was told by his roommate to expect a package of, quote, some marijuana, and it's a controlled delivery. He opens the door. It's handed to him by the police officer. The package itself is 12.46 pounds. He has it for a couple of seconds, and then the police come in and make the bust. So this is just a narrow set of facts where it's truly, truly an issue about whether the person is either willfully blind to it or knowingly has the requisite amount. And that's why I think, frankly, the legislature drafted the statute the way they did. This is not the difference between 2 grams and 6 grams, or the difference between 10 grams and 5 grams. We're talking about 10 pounds. This is the medium-sized bag of dog food at the grocery store. I have a 4-week-old now. She's about 10 pounds. It's a substantial bundle. You know what you've got. If you've got 10 pounds of marijuana, we're talking about a substantial amount of weight. And initially, of course, the marijuana trafficking statute required 100 pounds for the threshold when it was initially enacted. And that amount came down through the years.
But if you're right, this same analysis would apply. As you said, it's even stronger for the cocaine statute. And you would have to be able to prove that a defendant knew 4 grams versus 6 grams. And I would defy most people to put 4 and 6 grams in their 2 hands and tell the difference.
Well, I disagree slightly, Justice Namias, and here's why. Because the cocaine trafficking statute is 28 grams, and that's right at an ounce, which is
Right, so let's say 26 grams and 30 grams.
If that's the legislature's dividing line.
But how does the state prove somebody possessed 30 grams as opposed to 26 grams?
You mean knowingly possessed 26?
Knowingly possess that.
Well, a couple responses. That's not where they drew the line. They drew the line as an ounce, as the threshold amount. They're not saying the difference between 10 and 28. They're saying the threshold is 28 grams, which is common parlance in drug terms, as you know, an ounce, which is, remember, we're talking about this is a commerce activity, okay? So we know when you're dealing with an ounce of cocaine, there's substantial amounts of money involved in these cases. The parties who are involved know what amount they're going to get. There's really, drug cases don't have extra drugs tossed in like a baker's dozen. These things are calculated ahead of time. They're negotiated just like any business transaction, and you're not getting extra. they're not throwing some more in that you didn't know was there. Really, the strongest argument for the state, and the same was true in Flores-Figueroa, if you look at the oral argument there in the briefs in that case, the strongest argument for the state is this might make it slightly more difficult for us to prosecute individuals. And that's just going to be true in some cases, for instance, Mr. Wilson's case. But that's really no argument at all.
You made a cursory rejection of the legislative acquiescence, but that is a pretty good argument, isn't it? That there was a good period of time where they mended it in other ways after the Court of Appeals decision?
I disagree, Justice Carley, and here's why. If you look at the marijuana trafficking statute, the subsection C, there's not amendments to marijuana trafficking statute that, I mean, the statute was changed for lots of reasons. We had the whole question about, you recall the savings clause and whether there were several changes that happened in the 80s. But marijuana trafficking's really only been changed 3 times since its inception. It started in 1980 saying any person who is knowingly in actual possession of, in excess of 100 pounds of marijuana. That was 1980. Significant change, 1982. Any person who knowingly has actual possession of a quantity of marijuana exceeding 100 pounds, that was 1982. And then in 1988, we had a change from all the trafficking statutes, from the Lockwood decision from this court, 1988, that said actual possession means actual possession. You can't have constructive possession. So after Lockwood, they took out actual possession, and the statute has basically remained the same. And here, let me also offer this. We know the legislature, if we're going to assume from legislative acquiescence, which I don't know that this court has ever said, legislative acquiescence is a canon of construction, especially not where this court's not passed on the matter, and where it's never been construed. Really, this statute's just simply never been construed for marijuana. But even if it is, we know the legislature knows how to draft a statute that would remove the question of mens rea from the quantity. They would simply say it's unlawful to possess marijuana, like they do for the general possession statute in 161330J. It's unlawful to possess or possess with intent to distribute marijuana. Simple as that. And then have penalties laid out somewhere else, which, by the way, we have in the federal statute, 21 U.S.C. 841. That's exactly how 841 reads. It's clear in 841, it's just unlawful to possess marijuana or possess with intent to distribute marijuana. The penalties are laid off somewhere else. That's how you divorce, that's how you cleave, that's how you remove the mens rea element from the amount. It's as simple as that.
Are you aware of any other state with a similarly worded statute that is held in the direction you have?
Justice Carley, I'm aware of one state that has.
I'd like to be Justice Carley, but
I'm sorry, Justice Nami. I apologize for that.
That's all right.
They're both fine people.
Yes, they are. People versus Ryan, which is a New York case, and that's 626 Northeastern 2D 51. It's a 1993 case. But I only offer that to show you that there are other courts that have looked at really dissimilar statutes, really dissimilar statutorily by use of language, very different statutes, and come out different ways than the ones offered by the appellee in their brief here. That statute's not drawn like the Georgia statute. It's drawn like all the other statutes, by the way, that are cited by the appellee. And I did want to just briefly mention those. The appellee points to Florida, Missouri, North Carolina, Alabama, and South Carolina in their brief. Not a single one of those statutes is even close to the Georgia statute on marijuana. That's the first thing you look at when you notice those statutes. Missouri and North Carolina, by the way, don't even use the word knowingly at all in their statute. It doesn't even have the mens rea piece in it. Florida has a statute which is more similar to the way the Georgia statute was originally written. And it says, any person who is knowingly in actual or constructive possession of comma, 28 grams or more of cocaine. And I'm emphasizing the comma simply because of the canon of construction that's been recognized by the U.S. Supreme Court and other courts. If you have so-called interruptive punctuation, that can be an indication of the end of a state of mind, mens rea, the comma. And that's what you find really in every single one of these other courts. The Florida case, the Alabama case, and those are the two big ones. But if you look at the South, I'd point you to the dissent in the Alabama case, by the way. If you haven't read it, it's wonderfully worded dissent, pointing out that, look, even with that comma, this is probably, state of mind should extend to all the subsequent elements. And the reason being, Your Honors, is because, this is pointed out by Flores Figueroa, if you have a state of mind mens rea, a traditional mens rea, the model penal code and the general statute of construction is that it applies to every subsequent element in the statute. That's the rule. It's model penal code section 202, paragraph 4, but it's really embodied by the Flores Figueroa decision. If you have a state of mind mens rea, it's going to apply to all the subsequent elements of the statute unless there's some clear indication that it doesn't. The federal rule is an excellent example, 841. It says knowingly in Part 1, but Part B, in a separate paragraph, it rattles off the amounts and the weights.
Can I ask you one other question?
Yes, sir.
Was there an objection raised at trial on this issue? Or are we here on plain error review?
We're here on both plain error review and we are here on sufficiency of the evidence, Your Honor. Both. So no, and I didn't represent the appellant at trial. It was a private lawyer in town, and that issue was not raised by his counsel.
Well, okay. At least for the plain error part, the complaint about the instruction, if the existing law, at least in the Court of Appeals, says you don't need to prove weight, can you say that's a plain error?
Two responses. That wasn't the law in the Court of Appeals because no one had ever passed on the marijuana trafficking statute,
Okay, well,
subsection
let's
C.
just say if the law isn't clearly in your favor, as you're admitting the law isn't clearly in your favor, you're asking us to make a new